European competition law promotes the maintenance of competition within the European Union by regulating anti-competitive conduct by companies to ensure that they do not create cartels and monopolies that would damage the interests of society. With a history that traces back to the prohibitions on the restraint of trade, and influenced by the experience of the United States Sherman Act 1890 and the Clayton Act 1914, European competition law today derives mostly from Articles 101 to 109 of the Treaty on the Functioning of the European Union, as well as a series of regulations and directives. Four main policy areas include cartels, or control of collusion and other anti-competitive practices, under Article 101 of the Treaty on the Functioning of the European Union, market dominance, or preventing the abuse of firms' dominant market positions under Article 102 TFEU, mergers, control of proposed mergers, acquisitions and joint ventures involving companies that have a certain, defined amount of turnover in the EU, according to the merger regulation. State aid, control of direct and indirect aid given by member states of the European Union to companies under TFEU Article 107. This last point is a unique characteristic of the European competition law regime, as the European Union is made up of independent member states. Both competition policy and the creation of the European single market could be rendered ineffective were member states free to support national companies as they saw fit. A 2013 Civitas report lists some of the artifices used by participants to skirt the state aid rules on procurement. Primary authority for applying competition law within the European Union rests with the European Commission and its Directorate General for Competition. Although state aids in some sectors, such as transport, are handled by other Directorates General, the directorates can mandate that improperly given state aid be repaid, as was the case in 2012 with Malev Hungarian Airlines. History. One of the paramount aims of the founding fathers of the European Community, statesmen around Jean Monnet and Robert Schuman, was the establishment of a single market. To achieve this, a compatible, transparent and fairly standardized regulatory framework for competition law had to be created. The Constitutive Legislative Act was Council Regulations 1762. The wording of Reg 1762 was developed in a pre-Van Gend-en-Loos period in EC legal evolution, when the supremacy of EC law was not yet fully established. To avoid different interpretations of EC competition law, which could vary from one national court to the next, the Commission was made to assume the role of central enforcement authority. The first major decision under Article 101 was taken by the Commission in 1964. They found that Grundig, a German manufacturer of household appliances, acted illegally in granting exclusive dealership rights to its French subsidiary. In Constantinamp, Grundig, the European Court of Justice upheld the Commission's decision, expanded the definition of measures affecting trade to include potential effects, and generally anchored its key position in competition law enforcement alongside the Commission. Subsequent enforcement of Art 101 of the TFEU Treaty by the two institutions has generally been regarded as effective, yet some analysts assert that the Commission's monopoly policy has been largely ineffective, because of the resistance of individual member state governments that sought to shield the most salient national companies from legal challenges. The Commission also received criticism from the academic quarters others. For instance, Valentine Cora, an eminent legal analyst in the field, argued that the Commission was too strict in its application of EC competition rules and often ignored the dynamics of company behavior, which, in her opinion, could actually be beneficial to consumers and to the quality of available goods in some cases. Nonetheless, the arrangements in place worked fairly well until the mid-1980s, when it became clear that with the passage of time, as the European economy steadily grew in size and anti-competitive activities and market practices became more complex in nature, the Commission would eventually be unable to deal with its workload. The central dominance of the Directorate General for Competition has been challenged by the rapid growth and sophistication of the national competition authorities and by increased criticism from the European courts with respect to procedure, interpretation and economic analysis. These problems have been magnified by the increasingly unmanageable workload of the centralized corporate notification system. A further reason why a reform of the old Regulations 1762 was needed was the looming enlargement of the EU, by which its membership was to expand to 25 by 2004 and 27 by 2007. Given the still developing nature of the East Central European new market economies, the already inundated Commission anticipated a further significant increase in its workload. To all these challenges, the Commission has responded with a strategy to decentralize the implementation of the competition rules through the so-called modernization regulation. EU Council Regulation 1/2003 places national competition authorities and member state national courts at the heart of the enforcement of VARTS 101 and AMP 102. Decentralized enforcement has for long been the usual way for other EC rules. Reg 1/2003 finally extended this to competition law as well. The Commission still retained an important role in the enforcement mechanism, as the coordinating force in the newly created European Competition Network. This network, made up of the national bodies plus the Commission, manages the flow of information between NCAs and maintains the coherence and integrity of the system. At the time, Competition Commissioner Mario Monti hailed this regulation as one that will revolutionize the enforcement of VARTS 101 and AMP 102. Since May 2004, all NCAs and national courts are empowered to fully apply the competition provisions of the EC Treaty. In its 2005 report, the OECD lauded the modernization effort as promising, and noted that decentralization helps to redirect resources so the DG Competition can concentrate on complex, community-wide investigations. Yet most recent developments shed doubt on the efficacy of the new arrangements. For instance, on the 20th of December 2006, the Commission publicly backed down from unbundling French and German energy giants, facing tough opposition from member state governments. Another legal battle is currently ongoing over the E.ON-Endesa merger, where the Commission has been trying to enforce the free movement of capital, while Spain firmly protects its perceived national interests. It remains to be seen whether NCAs will be willing to challenge their own national champion companies under EC competition law, or whether patriotic feelings prevail. Cartels and collusion. Possibly the least contentious function of competition law is to control cartels among private businesses. Any undertaking is regulated, and this concept embraces de facto economic units, or enterprises, regardless of whether they are a single corporation, or a group of multiple companies linked through ownership or contract. cartels to violate TFEU Article 101. Undertakings must then have formed an agreement, developed a concerted practice, or, within an association, taken a decision. Like U.S. antitrust, this just means all the same thing, any kind of dealing, a contact, or a meeting of the minds between parties. Covered therefore is a whole range of behavior from a strong handshake and written or verbal agreement to a supplier sending invoices with directions not to export to its retailer who gives tacit acquiescence to the conduct. Article 101 prohibits all agreements between undertakings, decisions by associations of undertakings and concerted practices which may affect trade between member states and which have as their object or affect the prevention, restriction or distortion of competition within the common market. Quote, this includes both horizontal and vertical agreements, effectively outlawing the operation of cartels within the EU. Article 101 has been construed very widely to include both informal agreements and concerted practices where firms tend to raise or lower prices at the same time without having physically agreed to do so. However, a coincidental increase in prices will not in itself prove a concerted practice. There must also be evidence that the parties involved were aware that the behavior may prejudice the normal operation of the competition within the common market. This latter subjective requirement of knowledge is not, in principle, necessary in respect of agreements. As far as agreements are concerned, the mere anti-competitive effect is sufficient to make it illegal even if the parties were unaware of it or did not intend such effect to take place. Exemptions to Article 101 behavior fall into three categories. Firstly, Article 101 creates an exemption for practices beneficial to consumers, e.g., by facilitating technological advances but without restricting all competition in the area. In practice, the Commission gave very few official exemptions and a new system for dealing with them is currently under review. Secondly, the Commission agreed to exempt agreements of minor importance from Article 101. This exemption applies to small companies, together holding no more than 10% of the relevant market. In this situation, as with Article 102, market definition is a crucial, but often highly difficult matter to resolve. Thirdly, the Commission has also introduced a collection of block exemptions for different contract types. These include a list of contract-permitted terms and a list of banned terms in these exemptions. Metropole Television v. Commission Case T-112/99, ECR 2459. Vertical restraints exclusive purchasing Sabrasserie de Hecht v. Consorts Wilken Janssen Case 2367, ECR 407. Stereos Delimiters v. Henninger Brau AG Case C-23489, ECR I-935. Courage Limited v. Crean Case C-45399. Franchising Pronuptia de Paris GmbH v. Pronuptia de Paris Irmgard Schilgalis Case 16184, ECR 353. Export Bans Society Technique Minier v. Maschinenbau Ulm GmbH Case 5665, ECR 337. Musique Diffusion Française v. Commission Cases 100-103/80, ECR 1825. Javico International and Javico AG v. Yves Saint Laurent Parfums C-306/96, ECR I 1983. Constant and Grundig, also. Exclusive distribution L.C. Nungus Akagi and Kurt Eisel v. Commission Case 258/78, ECR 2015. Constant and Grundigen Maschinenbau Ulm. Also, Selective Distribution Metro SB Grossmarkt AG GmbH and AMP Co. KGV Commission Case 2676 ECR 1875. Metro SB Grossmarkt AG GmbH and AMP Co. KGV Commission Case 7584 ECR 3021. KC-250 90 seconds. Gottrop Tim E. A. Grove Verordninger wie Dansk Landbrugs Grove Vareselskabamba ECR I 5641. Case D-328-03-02 GmbH and AMP Co. OHGV Commission ECR E1231 T-374 T-375 94 T-384 94 T-388 94 European Night Services v Commission ECR 3141. KC 439-09 Pierre Fabre d'Hermo Cosmetic Schachfe Président de la Autorité de la Concurrence and Ministre de l'Économie, de l'Industrie et de l'Emploi. Commission Regulation No. 332/10 of the 20th of April 2010 on the application of Article 101 of the Treaty on the Functioning of the European Union to categories of vertical agreements and concerted practices OJL 102/1. Commission Regulation No. 461/2010 for motor vehicle sector. Joint Ventures Article 101. Merger Regulation